How you doing, man? Thank you. Thanks for joining us. This is Highly Educated Media Podcast. You know me, AJ Fabrizio, my co-host, Matt Gunther. Matt has put together a really informative presentation over several subjects in the progressive agricultural movements. But Matt, why don't you go ahead and take it away?
Hey, AJ, thanks so much for the introduction. To anybody watching that doesn't know who I am, my name is Matt Gunther. I'm the owner of Chemical.legal, and I'm also AJ's co-host on this Highly Educated Media podcast. And today I wanted to go through a presentation about the fall of Chevron and some of the considerations for counterculture. I'm doing this because there's a big trade show next week, the Champs Trade Show, one that I've gone to several times. AJ's always been a staple there as well. And I know that there's going to be a lot of discussion around three primary topics. So the purpose of this presentation is to kind of get ahead of the game here and begin the discussion a week ahead of time and kind of lay out for you guys some of the things that I think are most important to the counterculture industry right now based on the Supreme Court rulings from a few weeks ago. So for those of you, I just want to say we probably have a pretty broad spectrum as it pertains to legal knowledge. Probably some, very qualified attorneys watching, probably some people who didn't attend law school, maybe don't know some of those considerations. So, it's not streamed. I want to make sure this is good.
Yeah, make sure the stream's happening.
Sorry, we're just going to check with our producer real quick if our producer can verify that we are streaming. Good. Okay, cool. So we are live.
Great. Awesome.
Good. So back to that. For those of you who may not be familiar with what Chevron is or was, I'm going to give you a very, very simple breakdown of what occurred and why it was important. So traditionally, our government has three branches of government. There's the legislative branch, the executive branch, and the judicial branch. And the legislative branch, Congress, is tasked with writing and passing laws. And once they've passed a law, that law goes to the head of the executive branch, and they, if they're happy with it, sign it into law. That law is enacted, and the executive branch is tasked with enforcing that law. Along the way, problems arise between the legislative branch, the executive branches, citizen to citizen, corporation to corporation. And thankfully, the judiciary is there to attend to those issues as they arise. And that, in a nutshell, is how the country is supposed to work and has always worked. The problem is that beginning 40 years ago, technology has made the world very complicated, and there wasn't enough time to write all of the laws, or so was said. There wasn't effective legislation coming down for such new, rapidly developing areas, right? And because of there being absent language, because there was no legislative language or definitions pertaining to certain topics, what happened was regulatory agencies started using their expertise to define terms that were otherwise undefined. A ruling some 40 years ago by the Supreme Court verified that those regulatory agencies have the authority to do that absent a clear and concise legislative definition, right? So for the last 40 years, many conservative jurists have been upset that regulatory agencies have largely been able to define terms when, in their viewpoint, they felt that was the purpose of Congress and the legislative process. So what happened 2 or 3 weeks ago is the Supreme Court got together and overturned Chevron. So they overturned the Chevron deference, the ability to defer to a regulatory agency and their definitions for rules and regulations absent a legislative definition. So that is a very big deal, and it impacts much more than cannabis. It impacts the day-to-day operations of our government, and much of the next 10 years will be determining where the constitutional and procedural law issues of our time fall into one of three categories. So there's the category of things that will be immediately impacted by the fall of Chevron. There is the category of things that can now be challenged due to the fall of Chevron. And that is a very big and broad category. And then there are things that really won't change much at all, even though a lot of people think they might and should be able to change because of it. But that middle section, the section of things that can now be challenged, like I said, is very broad. And much of the constitutional and procedural law discussion of the next 10 years will be determining where those issues fall into those three categories and then how they will be litigated accordingly. So with that, AJ, I'm so thankful to have you here, because I could sit on my soapbox and talk all day, but we wouldn't get anywhere with that. You, as a listener, as somebody who may not be as familiar with these things, do you have any questions, or do you think that was a pretty good breakdown for the people watching at home?
So yeah, so basically what you're saying to me is, in the past, what Chevron allowed for was, if there was ambiguity, or maybe rules weren't written to the fullest extent necessary, then it basically gave the authority to the individuals in the regulatory bodies, not the actual. So basically, they gave unadulterated power to the regulatory bodies, as long as it didn't fly in the face of the law that was legislated by Congress and or the states or whatever it might be. Now they're saying, even if there's ambiguity, unfortunately, those regulatory bodies no longer have that authority to be able to say, hey, well, we think this is what it meant, or this is that correct?
And to answer your question, yes and no. What it means is there is no longer a deference that is reliable. So there is no longer this automatic deference, which means that, and to clarify, there's a lot of people at home, especially as it pertains to THCA in individual states such as Florida, that are saying, well, now with the fall of Chevron, I can do whatever I want. The government can't tell me what to do unless there's a law on the books telling me I can't do it. That isn't the case. What it means is, if somebody challenges you on something and you think that it was based on a regulation and not a piece of legislation, that you can then challenge them back. It does not mean you're going to automatically win, because every jurist is different. And at the end of the day, it's the judiciary that is now going to make the decision. What Chevron did was it consolidated power that was once in the regulatory agencies that a lot of conservative jurists tried to figure out how it even ended up there in the first place. And it's now given it back to the judiciary up until the legislative branch effectively legislates everything. So
that makes sense.
But I think, are we good with that, AJ?
Yeah, no, that makes a lot more sense. So it's not that maybe giving an example, like what's been happening in Florida with in certain areas where they've been red taping a lot of product and holding it. The Chevron being reversed would potentially favor an argument for those individuals who feel like they've been wronged, but it's not a guarantee.
Correct. It certainly helps what I've been told is an appeal in Florida. But again, everything has to be ruled upon. There has to be a decision made, and nobody's Nostradamus here, right? Nobody knows exactly how it's going to play out. So I just want to let everybody know, for people thinking, oh, Chevron fell, now I can do whatever I want, that might not be the best attitude to have. So I just want to clarify that for the people watching.
Awesome.
So now, based on that, let's talk about the rest of the agenda for the day. And each slide here is going to be a little more concise and consolidated. And if you guys have any additional questions, you can feel free to reach out to us. We're happy to answer them individually. But we're going to go over a synopsis of THCA and its current legal status. We'll talk about what it looked like before the fall of Chevron and how the fall of Chevron impacts that. We're going to talk about some of the other Supreme Court rulings that probably didn't make the waves that Chevron did, but AJ and I thought they were very important. AJ and I even made some videos about some of the other ones. There was one that had to do with the SEC that caught my attention, but really there was one that had to do with bump stocks and the ATF that was particularly fascinating to me. And if you have time, if you're on our YouTube channel, go check out the video AJ and I made about bump stocks and that ruling, because we made that video before the fall of Chevron, thinking that something like Chevron may occur. So go ahead and check that out. Then we're also gonna, because this is a Champs presentation, we're gonna switch gears to kratom or kratom or kratom, Mitragyna speciosa, a lot of different pronunciations here. We'll get through that later. And then the last section of this is gonna involve two very particular topics. And the first is the DEA's position letters and their impact on your business. As you know, the DEA has taken positions regarding hemp-derived cannabinoids that much of the hemp industry has not taken, and I'll explain that and what that means for your business. And then I also want to acknowledge a tryptamine compound that's been proliferating across the marketplace here called 4-ACO-DMT. I want to talk about the Federal Analog Act because many people in cannabis don't know this, but that Federal Analog Act and its relatives overseas are my actual area of expertise. The only reason I know anything about chemistry and law and was able to make a career out of it is because of the Federal Analog Act and those Analog Act considerations. So with that, I'd like to move on to topic one. AJ, you got anything for me on that?
No, I think that we jump right in because I'm really excited, especially once we paint this picture in these first couple sections, really explaining probably the meat and potatoes that people are mostly interested in is like, well, how does the DEA play into this? What do I have to worry about? So go ahead, keep going, man. You're doing great.
Cool, man. So the first thing I want to bring up here is this is the Code of Federal Regulations, Title 7. And this is section 1639.0. So this is where you can find the actual legal definition of hemp in this country, right? So a lot of people will talk about the Farm Bill, and yeah, that was legislation that did stuff. But if you want to see where the definition is memorialized, you got to go to the Code of Federal Regulations, Title 7, 1639.0. And you'll notice that the definition of hemp, I'm going to read this out loud for everybody. The term hemp means the plant Cannabis sativa L, and any part of that plant, including the seeds thereof, and all derivatives, extracts, cannabinoids, isomers, acids, salts, and salts of isomers, whether growing or not, with a delta-9 tetrahydrocannabinol concentration of not more than 0.3% on a dry weight basis.
So Matt, we've made a couple videos about this already, but this is kind of really, poignant considering there was an article yesterday that was published that was kind of making waves in the Atlantic. We had done a video a couple months before that, basically doing a much deeper dive on what they had covered. I personally, we'll get into a little bit later what it was, but like one of the things that I want to make sure that we emphasize through this is that as we're talking about cannabis, the plant cannabis, the two legal terms that define cannabis under the federal law are either hemp, which is the legal varietal of cannabis, and marijuana, which is considered the illegal varietal. So those are two legal terms that we use or that have been defined in law. And as you can see, Matt has read very specifically, and you'll see some more quotes as we go on, that it deliberately says only delta-9 THC. So anytime you hear people talk about total THC and all of that, that is conjecture. So, and we'll get into it more deeply as we go on.
Even in the final rule. And yeah, and to AJ's point, the thing that we want to bring up here, I love when you bring up that differentiation between hemp and marijuana, because THCa, as defined right here, we see the definition in front of us, as a cannabinoid and as an acid found in the plant Cannabis sativa L, there is no question that it is federally protected hemp and cannot be considered marijuana. That is the purpose of this legislation. That is the legislative intent of this law. Clear as day. There is no
and
loophole.
It's not a loophole. And you'll see later on, Matt has found some very good quotes from the final ruling. But remember everybody, delta-9 THC is not produced by the plant. Only the acid versions of all the cannabinoids are produced by the plant. So,
which leads me to the people that want to believe that this was a loophole, and we'll talk about this in the next slide. Nothing against you. I started my career on the traditional marijuana side of things, the I-502 initiative up in Washington State. I love the heroes that have done what they can do to bring access to cannabis when there was no access to cannabis. So if you're looking at hemp as a loophole and hemp's not your favorite thing, no hard feelings on my end. I appreciate all the work you do. I just want to explain to you how I arrived at my conclusions and why the big argument against hemp, I don't think is much of an argument at all. And that's in this slide right here. What about post-decarboxylation?
Yeah.
And so that is a big thing. The Farm Bill did many things. This piece of legislation did many things. It did two primary things. It issued two primary directives that are related but independent of one another. And that's really important to understand. So one of those directives is seen here on the left-hand side of your screen. That's section 297C. And you'll see it states Department of Agriculture. There is another section, another 297B, maybe some subchange there. And you'll see it references states and tribal plans. That is because the two separate, related but independent directives were for states and Indian tribes to develop a plan for the production of hemp in their states. And those states in those plans had to issue certain things. And one of the things they had to have was a procedure for testing. And we'll get into that. And that language is very similar to the language that you see here in 297C, which directed the Department of Agriculture, the federal Department of Agriculture, the USDA, to write rules and regulations about the production of hemp. And those rules are supposed to apply where states and Indian tribes do not have approved plans under 297B. Oh yeah, look, it's right there in the section for yourself. You can read it for yourself. So that's one of the other big misinterpretations of this. So the USDA has a lot of authority over the production of hemp when states and tribal plans have not been submitted and approved in those individual states and territories, right? So what's interesting, though, is that neither the federal regulatory agencies nor these states are allowed to redefine the federal definition of hemp. But by submitting and having a plan approved, what they were doing is signing on to the established legislated definition of hemp. And so the fall of Chevron is going to make everything very confusing for this regard. But I just want to turn everybody's attention. And there's an attorney named Rod Kite. He's fantastic. He does a lot of work for the industry. I'm very thankful for everything he does. And you can go to his blog and read all about these things. And he does a great job of analyzing that, to the extent that people want to talk about the legality of THCA. If anybody was going to make an argument about the USDA actually being able to test for THCA as a compliance metric, if there was going to be that being allowed, it would be limited to it as a production metric, to something being in the ground, because that's something this farm bill, this legislation, it had to do with the production of hemp. That's literally the subtitle, is the production of hemp. So there isn't basically any legislation, very little, surrounding the downstream products associated with the hemp plant and those products when they're testing below the sole compliance metric of 0.3% delta 9 THC. So on post-decarboxylation, the only thing I want to bring up is in this section, they state a procedure for testing using post-decarboxylation or other similarly reliable methods delta 9 tetrahydrocannabinol concentration. So to clarify, regardless of the language used, whether you post-decarboxylate, the metric that they're testing for is delta 9 THC. And post-decarboxylation is not a requirement. It's a word they happen to throw out that isn't necessarily even synonymous with any specific testing type. It's just a phrase. But if you wanted to associate it with gas chromatography, you have to recognize other similarly reliable methods, which if you go to the USDA's website, they state, and the final rule states this too as well, it's not just their website, their final rule states that liquid chromatography is absolutely an acceptable method, and they can bring up total delta 9 tetrahydrocannabinol all they want. We're going to get to that in a little bit. They didn't define it properly. But the fact of the matter is, if you show up with hemp and you have an LCMS result and it's below 0.3% delta 9 THC, it is federally compliant hemp. That is for sure. And for those of you who think that I'm lying, and for those of you who think that this is a loophole and that total THC is absolutely something that the USDA can use as a compliance metric for hemp, I want you, this is the big thing. This is the volcano eruption of this presentation. This is from the USDA's final rule itself. This is an excerpt from page 84. And it's when the agricultural marketing services are discussing the comments they received about the total THC requirement and how it was unconstitutional. And the AMS acknowledges that in the letter that was cited, that Senators Merkley and Wyden asserted that requiring hemp samples to be tested using methods by which the reported THC concentration accounts for the conversion of THC to THC, their quote, these are the authors, the people who wrote the Farm Bill, their interpretation of that is, and I quote, "It's a complete reversal of the congressional intent expressed in that law and requires testing that Congress specifically did not include."
So hold on. Let me.
I'll shut up now,
this is huge. This is what we've been talking about for months and months and months, and it hasn't changed since 2018. Whether or not people have become educated, but this is really important because that article that we were referencing before that came out yesterday in the Atlantic is titled "Congress Accidentally Legalized Marijuana 6 years ago," or legalized cannabis 6 years ago, and that's not true. It wasn't accidental. And there were several years after it was signed into law back in 2018 where they reviewed this, and then they had the final rules and a 301-page document, if I'm not mistaken, published in 2021, where this reference comes from, citing specifically this. These senators knew exactly what they were writing into law, and they knew what they were getting Congress to vote on. And so for people to sit there and say that it is a loophole, and there are a lot of people who are claiming to be experts in this who have not read the documents like you and I have. And Matt, I really love and I appreciate the fact that you've come out and you've found these references and we're presenting them this way because it's not our opinion. This is and with what you said with the fall of Chevron, that means that this is even more codified because this is very specific.
And that's what I wanted to talk about. So we'll get to the last slide here about THCA. Or no, this isn't the last slide, second last slide. I want to bring up the idea that the USDA knows this. The USDA repeatedly states in this final rule they do not have authority to alter the statutory definition of hemp. And so if you notice in their definition, this is Part 990, this is their definition section, the acceptable hemp THC level, in those definitions, you can read it for yourself, it's right there in front of you, it involves, the word they use is delta-9 tetrahydrocannabinol. They don't bring up THC, and that's important because a lot of people will say, but it says total delta-9 tetrahydrocannabinol. Well, read through the definition section and read through what that means, because total THC is a defined term and is defined to mean something. And they don't use that term here. They don't use that defined term. They use the term delta-9 tetrahydrocannabinol. For those of you saying, no, they're using the phrase total delta-9 tetrahydrocannabinol, that's an undefined term. That doesn't mean anything other than just what it means, which is just the total amount of delta-9 tetrahydrocannabinol, not the total amount that could potentially exist if and when it's decarboxylated. So for those of you claiming the Farm Bill requires decarboxylation, according to the senators who wrote it, no, it does not. And according to the USDA who defined the term, they define total THC, but they just never bothered to use it in acceptable hemp THC level. Ergo, delta-9 THC, a compound the plant does not produce, is the sole legal compliance metric for cannabis in the United States of America.
And to drive that point home a little bit more, everybody remember this. There is no authority like the DEA in this bill, the Farm Bill. They removed the authority of the DEA over hemp. So these are no longer criminal charges. And for the fact, and we'll get into this later because there's a lot of scare tactics that have been happening and a lot of opinions that have been happening. But like as far as if you think of it this way, as far as the plant goes, since it does not produce delta-9 THC and THCA may and can decarboxylate under the right conditions, but also could be stored indefinitely under the right conditions and not have any changes to it. There's a very small window in which a cannabis plant could be considered marijuana. When you think about it, while it's growing for most of its life, it's not even producing these oils to begin with. Then when it starts producing the oils, it doesn't produce any of the controlled substance that would then legally determine it to be marijuana. And in order for you to get to that point of decarboxylation, you actually have to, kind of have to push it or put it under certain circumstances so that THCA can then decarboxylate and convert to delta 9 THC. So this is a huge, I cannot, I wish we would have brought up and we could have shown what the original definition under the Controlled Substances Act was, because they literally flipped it on its head, which is really great, because that's why we're seeing this explosion in the industry. I mean, $40 billion this year with $115 billion worth of ancillary businesses. And that's not even including, like I say, the big game, which isn't the cannabinoids. It's going to be all of the other things now that we've allowed for the USDA and for farmers to start growing it as a commodity, And so I'll get off my soapbox, but it's really important that people realize that there is no ambiguity in the federal law. There is zero ambiguity.
I want to state that this definition sections, if you notice, they state it does not affect the statutory definition of hemp. It also, though, while it doesn't affect the statutory definition of hemp, to the extent that USDA has authority, it states that for the purposes of USDA, 0.3% is not the compliance metric. It's 0.3% plus or minus the measurement of uncertainty. So for those labs that are saying, this isn't hemp, this is marijuana, but they're not including a measurement of uncertainty, according to the USDA, you don't have the authority to make that claim. So just want to throw that.
And we know firsthand that's been happening quite a bit in certain states that may not have as much of a forward-thinking perspective, but again, and the devil's in the details. The real number is 0.35%, as you can see here.
Just an example.
And so, but again, with science and with measurement, there is always uncertainty, and you have to include those things. We also know in the final rules, and I don't know if we included in this, but there's also a negligence budget that was afforded to farmers and to producers because the 0.3% was just too encumbering. Because the reality of the matter is there are ways to remediate the delta 9 THC out as well, and having people destroy their crops just because it goes above a certain level, it was a waste of money.
And I will say this too, and then, AJ and I could do an entire presentation, and maybe we will, on that negligence budget. But part of that is remembering the United States is not the only country in the world, and many other countries are already at 1%, which was part of the reason the USDA decided to raise that negligence budget to 1%. So I'll get off this slide and on to the next one, AJ, because this is the actual last slide. And it's something I just wanted to show you, the idea that total delta 9 tetrahydrocannabinol, it's an undefined term. If you look through the final rule, I believe this is on page 63, you'll see the USDA state that hemp is defined as the definition you find in 1639. And they state the statutory definition is self-explanatory, and USDA is adopting the same definition without change for Part 990. Again, that is their definition section. That is where they define the terms. And even prior to the fall of Chevron, the idea that THCA was effectively regulated by the USDA, based on the language that I've seen in front of me today, I don't know that I can make that determination, seriously.
I agree with you. And I kind of want to bring another bit of attention to something that's kind of overlooked, is that little excerpt that says whether growing or not. So that's very important. Possessing cannabis, as long as it meets those metrics below delta 9 THC, below that point of delta 9 THC, it's considered hemp and it's legal. And so there's an interesting dichotomy now, like we were saying. There's the legal definitions for cannabis are either marijuana or hemp. States have medical marijuana and recreational marijuana laws where the federal government looks the other way. But the reality of the matter is, for the most of the time that they're growing their products, they're considered hemp under the statutory definition. When you think about it,
AJ, I'm so glad you brought that up, because you and I joke about this the whole time. The war between hemp and marijuana has always been particularly fascinating to us. But it's funny to me that with all the talk of rescheduling, there was the filing for 280E for the tax refunds based on rescheduling. And it's like, based on the federal definition of hemp, and for those of you who don't know what the tax problem is, the tax burden with marijuana, the problem is you can't expense anything that is associated with the production of a Schedule I controlled substance, right? So the problem, and anybody who's run a business knows that, being able to expense things is many times the only reason you're able to make any money or turn a profit at the end of the day, right? So those margins are really thin. Marijuana doesn't have the luxury of expensing anything. And that's insane. However, if the plant, whether growing or not, but is below 0.3% because the plant doesn't make Delta-9 THC, it stands to question this analysis, and that's why this presentation is so important. Marijuana companies all over the country should honestly be asking, are we producing marijuana? And at what part of the process is it marijuana, and what part is it hemp? And what expenses of ours are actually going towards producing hemp, not marijuana? So
absolutely. It's really interesting because the reality of the matter is the article was correct. In almost every fashion, cannabis is now legal, save this one situation, right, where Delta-9 goes above a certain level. And the sky hasn't fallen. And people are, what we're going to probably see is this confusion that will be promulgated by people who are looking to make money off of the industry. You've got medical and recreational companies that see this, what we're talking about, and are embracing it and saying, great, this is a great way for me to not have to pay taxes on this, or a way easier way for me to file, or an easier way for me to move money from state to state. All of these things you cannot do because the federal government controls the borders of the states. Now, if you're dealing with hemp, though, it's 100% legal. It's a legal commodity, and and none of those encumbrances exist. Not to mention, again, the federal government does not recognize medical marijuana or recreational marijuana. There have been huge amounts of, you could go and take classes on how to do your taxes if you're one of those two types of companies, to figure out ways to be able to write things off. Like Matt was saying, it's difficult, but under this paradigm, you don't need to deal with that anymore. And it's a beautiful thing. Never thought it would happen in our lifetimes, actually, to be honest with you, the way that it has in such a sweeping fashion. And what really is interesting to me is you basically have killed the business model of medical and recreational marijuana already, because they cannot compete. Yeah. And that's why we've been seeing companies spending $65 million throughout a bunch of states to be able to outlaw hemp production because they can't compete. And you and I have been on those calls. And when we drill down, they're honest. They're like, look, we have such exorbitant taxes. We have such exorbitant fees. We have all these things. How are we supposed to compete with something that is
we have kids that need to go to school? Like everybody's got lives to live. I mean, it's genuinely impacting the livelihood of people. So I understand where they're coming from.
100%. And
on that note, I think that.
Yeah, go ahead.
Oh no! I want to let you finish that thought because this is going to be the end of our.
I think you're right, and I'm not attacking one side or the other. I'm just saying it's a huge opportunity, because really these medical and recreational companies, I make the argument that the taxes were really more of a bribe, because I would assume that a tax should be a sin tax like we do with alcohol, because we know alcohol causes damage to society, so we tax it to help offset some of those damages. When in the states where they've done these studies, like Colorado, they find that they're saving money because cannabis is legal and all of these in many different areas. And so, I think it's unfair. Instead of hemp and marijuana companies being at odds with one another, I think they should be coming together and being like, hey, look, states, either you get with the program and you amend these taxes so that you can allow for these companies to thrive, or, we're just going to become hemp companies. And then there's no way that the state, unless the state passes a law that requires taxing on hemp. But, there's no reason for there to be this at odds with one another, because the reality of the matter is, like I always say, everybody wants to cut up the pie before it's finished baking. Let's make it as big of a pie as possible, so that whatever slice you get is more than enough. Anyway.
Wise words, very wise words, AJ. I like that. So on that note, I think we want to go back to the slides now, and we're going to bring up Kratom. or kratom or kratom.
Switch
It
gears.
is Mitragyna or Mitragyna speciosa is the name of the plant. It's a plant that's native to Southeast Asia. So most of it comes from Indonesia, but it grows in Vietnam, Malaysia, those parts of the world as well. And it's actually a member of the Rubicea family. So it's related to coffee. It's the same family of plants that contain the coffee plant. And it's gained popularity a lot over the last 2 years. It is by no means new. So I've been dealing with considerations associated with kratom for well over a decade. And I want to tell people who are just now getting into kratom some of the things that have occurred up until this point. So this plant has been used traditionally in Southeast Asia as a way for, among other things, a lot of things. It's got a bunch of different uses. So, anxiety, just mood lift, elevation stuff. But also they found that people that were suffering from opiate addiction could use this. People that use opium in Southeast Asia could take kratom and then not have to use opium anymore. And so traditionally for hundreds of years, it was used, among other things, as a way for people to not take opium in Southeast Asia. So when it first got introduced to the United States is up in the air, and it matters because of something called THCa, the Dietary Supplement Health and Education Act of 1994. So THCa states that any product or plant or chemical constituent contained within a plant that was part of the food supply, the United States food supply, prior to 1994, is automatically grandfathered in and can be marketed and sold as a dietary supplement or as a food product. If it was before 1994, there's really nothing that the regulatory agencies can do about it without jumping through extra additional hoops proving that it's really dangerous, so on and so forth. My research indicates that kratom began appearing in the United States of America, and specifically on the west coast of the United States of America, in the mid to late 1970s following the Vietnam War. So what happened was there were soldiers that came back that had tried and used kratom in Vietnam, probably among some other things they tried and used in Vietnam, and found that kratom, unlike probably some of the other opiates they encountered there, was actually a good fit for them or helped them with things in their life, right? Otherwise. So my research indicates that the East Asian markets that are commonplace in metropolitan cities throughout the West Coast of places like California and Washington were already importing kratom into the United States in the mid to late 1970s. I have some journal research hidden on a hard drive somewhere that has it. I got to go and find it. But if you're out there and want to do some research, you should really be, if you're a kratom advocate, you should be looking for any indication that kratom was part of the food supply prior to 1994, because that would grant it some room in the marketplace that it otherwise would not have. Now, the reason that matters is because over the last 20 years, beginning in the first decade of the millennium and then extending into the 2010s, kratom became a popular offering in two different places. So it became an offering as a consumer drink in kava bars, as a brewed tea, and it also became available for sale in smoke shops across the country for people that wanted to brew their own tea. And that was the leaf. So you'll see on here, there's the leaf, the extracts, and the isolates. For a long time, most people just use the leaf. And the leaf has a full spectrum alkaloid profile, the same way that cannabis has a full spectrum chemical profile of its own. But these chemicals are not related to cannabis. But I just want to let people unfamiliar with kratom know that there is more than just this one compound, mitragyny or mitragyny. There's a million different ways you can pronounce it. But there's a Dr. McCurdy, who's forgotten more about this plant than I'll ever know. And he seems to say mitragyny. So out of respect to him, I'll say that as well. But I just want to let you know that the full spectrum alkaloid profile of the leaf does not always match the extracts. And we're going to get into that shortly. So, AJ,
Matt,
do you have any questions?
Before you jump into that, so THCa, we were talking about.
Yeah.
So is there a beginning date? So it says anything prior to 1994. Does that mean like from the inception of the United States, or is there, or is it ambiguous?
Well, so again, it has to be part of the domestic food supply.
So why? So how? Just thought experiment. How does hemp not apply?
Oh, it's funny you bring that to go back to cannabis too much, but you and I had, it's one of the few things we haven't discussed. My other business partners and I have discussed it frequently in the past, but this whole thing with CBD, if you ever wanted to attack the FDA's authority to regulate CBD, you could have said that hemp was part of the food supply prior to 1994. CBD, a constituent entity of hemp. What complicates that argument now is Epidiolex. So what complicates the argument is the fact that it is now an approved drug in the United States prior to it being grandfathered in as a dietary supplement.
Well, so, that's interesting. I was unaware of DHCa.
That was very important. Yeah.
Yeah, I was unaware of that. I mean, so anyway, I don't want to take away from this part of the conversation, but that's really fascinating. I wasn't aware that existed, that law existed, and it's a good law. That actually is a very smart law to be having. So yeah, continue. Exactly. Actually, I have one more question about kratom.
Mitragyna, we'll say today.
Yeah, Mitragyna.
Tomorrow it'll be a different one.
Maybe before you get a little bit deeper into, could you explain? I've been under the impression from what I've read that it has a biphasic effect, meaning that it has different effects at different dosages, right? And they can be completely different effects, right?
Yeah, that's what's interesting. And again, so I'm going to paraphrase the research of the good Dr. McCurdy here, and hopefully not butcher it too bad, but based on the research that's been made available to me, in lower doses, whether it's the full alkaloid profile of kratom, or there seems to be some evidence that it is mitragynine dependent, largely dependent. In smaller doses, it seems to provide a more uplifting, almost stimulant-like effect, almost more than stimulant, a clear-headedness to it, kind of associated with coffee of all things. So, this is in the coffee family. We're in our infancy of understanding what these plants do. Even coffee, a lot of people don't realize, has peptides in it that interact with the opiate receptors. So, the idea, maybe it doesn't have specific alkaloids, but there's pathways that develop over time for different reasons. Who knows why? But yeah, I guess to your point, AJ, in lower doses, more of an energy coffee-like effect. In higher doses, more associated with sedation, right? Being a sedative kind of effect. But again, that goes along with the traditional use of somebody that had been taking opium or a traditional opiate product and wanted to stop, but couldn't because they would get sick. They could take kratom and then they wouldn't get high or they wouldn't get sick. And that was a good thing for those people throughout hundreds of years in Southeast Asia. And it seems to be that the Vietnam War catalyzed the initial popularity here in the United States. And then as things like technology and the internet became more commonplace, word about kratom, was sure to spread. And that is indeed what has occurred.
Thanks for explaining that, because I think there's a lot of misunderstandings around this, and it's kind of a contradictory idea, right? You can get two totally different effects from the same plant depending on the dosage that you take.
And I want to let you know, to anybody looking, if you hear me say the word opiate, again, that's what makes this plant so controversial, is because its alkaloids do have the potential to interact with the opiate receptors of the human body, along with other receptors. There's parts of this plant that are serotonergic, and so we'll talk about that. So, but opiates, listen, if that's a word that scares you, you're not hurting my feelings at all. We have a tremendous opiate crisis in this country. It's unparalleled in any other part in the world. And the only reason I would ever be interested in something like this is to try to research and develop ways to use it to help people. That's the only thing we would ever want to do. And later on in the conversation, we'll get to some of the disclaimers. You'll learn a little bit about me and my positions on things. But I just want to clarify, if you're scared because you hear me use the word opiate, that doesn't make you a bad person. I want to let you know I'm not the guy who's out here trying to advocate for opiate use or anything like that. The way it interacts with the opiate system is very unique. It's not the way that hydromorphone or heroin or anything interacts with the opiate system. Totally different. And maybe someday I'll be able to give a presentation on that. But if it's scaring you hearing this, please know that I understand why it's controversial. And the only reason I'm talking about it is to try to find the ways to use the best parts of the plant to try to help our ailing society.
Absolutely. I agree with that 100%, Matt.
Yeah. So to tell you a little more about the plant, so I'll take you a little picture of a little baby kratom plant I had in the office some 8 years ago. There is some misinformation about the colors associated with kratom. So you're going to hear people talk about red, green, white, and sometimes gold kratom. And they're pretty consistently advertised as being different varietals, different strains, almost having different effects the way that different cannabis varietals would have effects, the way that you have your gelatos and your cookies and your all these different things. That's how they're marketed. And I think it does the consumer a tremendous disservice to market it like that. So part of the purpose of this presentation is to tell them the truth. So if you're watching this, you want to know what the kratom colors actually mean. They're associated with various post-harvest processing methods. They're not cultivars as with cannabis. So the red indicates a post-harvest fermentation process. So it's, and AJ and I'll talk a little bit about that later. The green varieties are the freshest air-dried leaves. Like if you're buying kratom, that is the most middle of the road kratom you're going to get, because they just take it right off the plant, dry it as quick as they can until it's dry, and give it to the consumer. And then white is different. It receives a lot of enhanced attention during those drying processes. And during those processes, they sometimes enhance the product with the bones or the veins of the plant. It's the concentrations of the plant that can make it appear brighter and whiter and lighter in color. And then gold is oftentimes just a mixture of those colors to achieve the desired color of gold or yellow that they're looking to achieve.
Yeah.
So yeah, AJ, I know you're not as familiar with kratom as maybe I am, and even I'm in my infancy of understanding it, as we all are. So if you have any questions about the leaf, let me know. But
so yeah, no, I think it's important that people understand that a lot of information is being promulgated that's incorrect. Like you were saying, it is the same species of plant every time. What changes its color, like you said, is the way that the post-production works. But again, like there's some uniqueness to it, right? Obviously, depending on how post-production occurs, you can have some alteration of the actual chemical profiles. I presume fermentation has some interesting effects that vary from just air dried, and I presume, I'm guessing these techniques have been honed over hundreds of years from where they were from, and typically people's learn through process of elimination and they go through a process because it actually creates a certain effect. Even if they didn't have science to prove what it was, they had proof in the actual product of the effect of using it over and over again. So I guess the most important thing is a lot of people try to compare it to like strains of cannabis, which I think is pretty incorrect, right? That's what you're saying?
Yeah, very much so. So I appreciate you highlighting that difference. So we're going to go to the extracts now. So this is what has changed the kratom market specifically over the last decade and really over the last 5 years. So when you buy kratom extract, you could be buying just about anything, but you're probably buying one of two different products. You're either purchasing a freebase extract, the profile of which you can see in front of you. And then you have, if you want to switch here, I'm just going to switch this very quickly, the salt. And so two different testing labs, and I'll explain that differently. But what you'll see is the salt, while it has a higher MIT, instead of Mitragyna, instead of Mitragyna, I'll start saying MIT, because you might hear MIT in the industry, and it's obviously easier to say. So the MIT content of the salts might be higher than the freebase extract, but if you notice at the bottom, the total alkaloid profile only comes in at just under 74%, 73% change. Whereas when you have a good full spectrum freebase extract, that was provided by a business partner of mine. If you want to know how to source the real stuff, feel free to reach out to AJ and I after this. But this is a true 99.99% total alkaloid kratom profile. And you can see the MIT content a little lower than the salt, but you can see it's a full spectrum. And those aren't small numbers. 21% of the secondary alkaloid there, almost 14%. Almost 11% of speciosa, so they make a tremendous impact. That's one thing that people from the cannabis industry, I hope they come to understand about kratom, is just like cannabis, all of the alkaloids, all of the constituent entities, all of those things make a profound difference for the consumer.
And Matt, I want to just real quickly jump in because we're hitting a lot of terms that people are probably triggering terms like opioid, freebase, salt. So maybe you could explain, because these are all scientific terms that were obviously taken in the media, and obviously, a lot of people have a very visceral response to hearing these words. So why don't we jump a little bit into like the difference and what freebase means versus salts, and that way we could kind of take the boogeyman out of it so people understand that they really are scientific terms.
Absolutely. I really appreciate you bringing that up, AJ. Honestly, this world is better with friends like you, because that is a big thing. I personally, as AJ alluded to, I don't have another term for freebase extract. Like, that is chemically the proper term here. And if it scares you, let me explain why it shouldn't. So every kratom extract is going to start as a freebase extract, because the purpose of a freebase extract, what is happening here, what that means is it's pulling the entire profile. It's pulling as much of the alkaloid profile as it can, right? And AJ, I just want to tell you about why they're doing this and how they produce a salt from a freebase. So to understand, if you're buying a salt, that salt at one point in time was a freebase. They had to extract the alkaloid out to convert it into a salt. So these extractors extract as many of the alkaloids as they can. And I just want to let you know, if you buy freebase extract on the market, it's not going to be the test report you see in front of you. It's somebody, AJ and I know, that specializes in this stuff. Most freebase extracts is going to come in between 35 and 50% MIT, so a little lower. And it's not going to have all the other good stuff, certainly not as much of it as you would like, because the extraction methodologies just aren't up to where we are right now. So there's no harm, no foul, but this is the best profile that you're going to see on the market. And that matters because once you have a freebase extract, whether it's our super high quality one or somebody else's, to produce a salt, that product is first separated into two different layers. And usually the process utilized is called sonication. And so by all these ultra vibrations basically are just separating out the material into, and it separates out high MIT, basically the MIT, from the rest of the alkaloids. So the problem with that is the kratom users that like the leaf and like the full spectrum, when they start sonicating it, they're losing a lot of these alkaloids that, believe it or not, were providing the experience they were actually looking for. Many of the users that use this, like a coffee, for example, they're not looking to get any pain relief. They're not looking to get any buzz. They're just looking for a little mood lift, just kind of the same way that you use coffee. And if you don't have all of those other alkaloids in there, if you're just giving that consumer a high product, they're never going to get the effect they want. And what's worse is they're probably going to take more and more of it, hoping to get an effect that they could never get from it anyway. So that's why I'm really grateful to work with the people that I work with. AJ, you know what I'm talking about. It's because they take the time to do this right, and it's because they care about the end consumer. So what happens now, once everything's sonicated, that's what.
No, go ahead, finish.
Oh, AJ, you there?
Yeah, go ahead and finish, and then I'll jump in and I'll say it after.
Okay, cool. Yeah, sorry, I think we lost due to technology there. But and once you have that separated out MIT, then they produce the salt. And so producing a salt, that's why what AJ was talking about with freebase and salts being chemical terms, if you ever remember sophomore chemistry class, you'll remember an acid plus a base equals salt and water. And what that means is if you have a free base extra, acid plus a base equals salt and water, if you take that free base and you react it with an acid, you are going to get a salt and water. So what people do is they take this free base mitragyny extract, this MIT, and they react it with an acid. So if you react it with acetic acid, you get the acetate ions. Citric acid, citrate ions. That's how it all. And they're producing the MIT salts. And the reason they do it is because they are extremely water soluble. So a good high quality free base extract like this, if you were to put it into a glass of water, it wouldn't freely disassociate into that water. And if you're a formulator or a manufacturer, that might be a problem, right? If you don't know how to work with the free base, which again, there's a very easy way to do it, and reach out if you want to know more about it, because you'll get a much better kratom profile if you use it. But the salt will freely disassociate into water because it's not just MIT, it's MIT plus the weight of the ion needed to create the salt. So you are getting, usually when you're buying a salt, you're paying more money for a lower quality product. So I'll bring up the salt report here. I'm not sure if we're having some technological errors or what.
I think the internet.
There we go. So that is the salt. So again, this salt like this. Yeah. So again, the salt, very water soluble, just not as high of a quality product from the consumer standpoint. All right. So the final thing about kratom, and then we're going to get into the section I've been looking forward to the most. Final thing about kratom is the emergence and prevalence of what's called 7-hydroxymitragynine. So this is it's produced through the oxidation of classic MIT. And everybody, for the years that I've worked with kratom for the decade now, has been very worried about this compound. They've been worried about it being effectively isolated, concentrated, synthesized, and becoming prevalent on the market because the pharmacological data associated with mitragynine has traditionally, as much research as existed up until, say, a year ago, indicated that it could be just as effective and or dangerous as compounds like morphine or even hydromorphone, that its interaction with the human body may resemble that of traditional opiates as opposed to something like MIT. So all of us have been very, very worried about 7-hydroxymitragynine hitting the market and in consumer products because of the fear of obviously addiction, the fear of respiratory depression, all those kinds of things. So, and obviously that's something we would never want to see. So the fact that it's as prevalent as it is now has scared a tremendous portion of the kratom community. What I will say is more and more data is coming out every day about this compound. And as it stands, it's now the real research seems to indicate that it's safer than would have been anticipated, which is great. But again, all of this, we're in our infancy with all of this. And the reason I'm giving this presentation is to be very candid about what all this is and, you know, what could be good about it, what could not be so good about it. But we have to be honest about it because when people aren't honest about it, that's when bad things happen. And that's when you could potentially cause problems for the consumer. It's potentially when you could encounter a tremendous amount of civil liability in terms of your own business. So I will say this to tell you that people purchase kratom in my research, for three distinct reasons. Some people purchase it as more of a just simple mood boost, kind of a coffee alternative like we discussed. And they get a kick out of those more serotonergic alkaloids, all those kinds of things. The leaf is good. They love the full spectrum profile of free base extracts and those products. But there's another type of consumer, really two other types of consumer, one that takes these products for pain, and then one that takes these products for a more recreational use, right? And three different users really need three different types of products. And the coffee people that are just looking for their mood boost don't need to take super elevated concentrations of isolated 7-hydroxymitragynine. So that is, if you see some of the concerns from the industry members, what people are concerned about is unsuspecting individuals who are just looking for a very safe, clean, and effective coffee-like buzz, accidentally entering into a realm of other products that are not intended for them, and other products that may actually serve very important uses in our society, but it's not some guy off the street trying to seek a coffee replacement, if you will. So I just want to be very clear about that, because if you're confused about kratom, and more importantly, some of the civil liability considerations associated with selling kratom, right now there aren't hardly any criminal considerations to be had for kratom, depending on the state and the locality. But running an effective business isn't all about not being a criminal. It's also about being an ethical member of our society and contributing to it. So if you want to be involved with kratom, but also want to do it the correct way, please reach out to AJ or myself, and we'll try to give you the guidance you need to be the person you want to be. So I guess
all right,
AJ.
To summarize what you were saying, people need to understand, and this is in general, I mean, you could apply this to cannabinoids. Potency does not correlate to effect or to experience always. That's why it's important for us to have these conversations, so that we can arm you with the information to help you get to where you're looking to be. Perfect example is what Matt was just explaining about how, some people you would like to utilize it as a coffee substitute, and those people should never probably be interested in the high purity extract that we were showing you in COA of, or certificate of analysis of, because they're probably going to be more interested in leaf, maybe like steeping tea, the same way that, it was originally done. Now, for those people who are looking to treat pain, they're in a totally different category, and they're probably more likely to be looking towards something that's formulated at a high degree, utilizing some extracts like that. And same with the recreational user. I think the recreational user is probably in between that whole spectrum. They're the gradient between the person who's looking for the coffee experience versus the person who's trying to treat pain. And so I think it's really important that people understand that just because you walk into a store and you see a product that says high potency mitragyny, that doesn't necessarily mean that's what you're looking for. It doesn't mean better or worse. It doesn't mean quality standards. You could apply these to be a quality standard, but it's not all of the quality standards, if that makes sense.
Yep, very well said. Yeah, potency and quality are two different things. There's correlation that doesn't necessitate causation, right?
Yes, exactly.
So let's see. And AJ, I think we're working with a little delay here. So on that note, I'll get back to the slides. This is what I feel to be a good time for the following disclaimers, especially based on the conversation we just had with kratom. So you should know, I am not an attorney. I know a lot about law, but I know a lot about procedural law and constitutional law, because those are the jobs that I've taken over the course of the last 15 years. That does not make me an attorney. It does not make me a substitute for an attorney. And you need to know that my discussion of legislative and regulatory considerations does not constitute legal advice. So don't go out and do something and then tell them that I told you to do it, because that's not the case. So number 2, I am not a physician. So anytime you hear me discuss chemistry or pharmacology, it's not intended to treat or cure or diagnose any disease or ailment. I don't know what the rest of America is doing with everything, and I'm not going to tell them to do that or not do it, because I'm not a physician. Whatever you choose to do, please don't do anything without consulting a physician. Physicians are important people. They earn their degrees. Please talk to them. Following point, and part of the reason I included parts 1 and 2 is because, above and beyond all things, I am not a criminal. So by committing myself to legal and ethical business practices at all times, I am neither knowingly nor willfully violating federal individuals engaged in actual unlawful criminal enterprises. So you should know that first and foremost. I'm here to provide information for the betterment of our society and nothing else, other than to hang out with AJ. So let's see. All right. And I say all that to now get to the piece de resistance of this presentation, if I do say so myself. So on the left side there, you'll see both the molecular geometry and the electronic structure of tetrahydrocannabinolic acid, better known as THCa. So, as you may or may not know, the DEA has decided to take the forward-facing opinion that 3 specific hemp-derived cannabinoids are not actually hemp-derived cannabinoids, that they are in fact controlled substances under the Controlled Substance Act. Those 3 chemicals are THCa, tetrahydrocannabinolic acid, THCO acetate, which refers to both delta 8 and delta 9 isomers of that compound, and then HHC, hexahydrocannabinol, which has 2 diastereomers, I believe, of it, both of which are referenced as being Schedule I controlled substances in the United States, in the opinion of the DEA. So there's a reason I've been following this, and I've been following it for the last 2 years, and a lot of it has to do with my background and my knowledge and expertise pertaining to the Federal Analog Act. It also has to do with the fact that I spent 15 years analyzing the DEA and the Department of Justice and their attitudes towards the Federal Analog Act. So I'm going to show you something in the next slide, because I thought long and hard about how to approach this topic and how to do it professionally and with courtesy to everybody involved. So I talk to a lot of attorneys, as you can imagine. I talk to attorneys all the time. And I spent the last 3 weeks running this next phrase by the network of attorneys that I frequent and asking what they thought. And actually, I also asked a bunch of attorneys I don't usually frequent. A lot of them were kind enough to respond and tell me their assessment. And the overwhelming assessment, and by that I mean I didn't have anybody disagree. I just had some no responses. But the overwhelming assessment was that I was absolutely reasonable in my creation of the following statement. So I want you to read this statement. Independent of the accuracy and or enforceability of these opinions, they are the DEA's forward-facing opinions, meaning they are likely being included in probable cause affidavits to request investigational authority if and when deemed appropriate. So that's a very simple phrase, and it's one of the reasons I want to bring this up is because I don't know what's happening. I don't know if anybody's looking into hemp, not looking into hemp. I don't know why they would want to. But in my experience in working federal cases associated with the DEA and the Department of Justice, I have found that one of the things the Department of Justice and the DEA like to do is some probable cause affidavits with chemistry-related topics that magistrate judges simply don't understand, so that they take the affiant's face value assessment as word and as being true, and then they issue the authority to start investigating targets of interest, and more specifically, their bank records and electronic communications. So again, I don't care. What it means, who knows? But when I saw those opinions come out, and this is just what I want to let the hemp industry know, if that is their opinion, and it certainly seems to be, then the idea that that opinion would be included on probable cause affidavits to request investigational authority makes absolute logical sense. And I just want the industry to know that. It doesn't mean a bad thing. You can investigate anything. It doesn't mean that there's anything there. I just want to let the hemp industry know that in my professional assessment of things, the opinions don't matter, the ability to justify a potential warrant into a potential target. And that's just something that I want the industry to know. And if you want to learn more about, for example, sometimes how the DEA and DOJ work together to confuse juries in order to secure convictions that they otherwise may not have been able to secure based on fact alone, I encourage you to buy the book you see on your left there, Bizarro. It's by an author named Jordan Rubin. He's a former special narcotics prosecutor from Manhattan. And he just did the most phenomenal job I could ever tell you about. It makes up the 3 books that I call my Bermuda Triangle of literary justice reform. So that book, The Grapes of Wrath, and then a book called Determined by Dr. Robert Sapolsky make up my Bermuda Triangle of criminal justice reform. So if you ever want to read that book, I really strongly recommend you read Bizarro if you're operating in the hemp industry to learn some of the things that I've known all along.
And honestly, everybody who's watching, the whole point of this presentation was to get to this. Matt and I have been deeply concerned about these things because although the public opinion has been becoming more favorable and more pragmatic about dealing with these situations, there's a lot of inertia that is still behind the old ways of interacting with these substances. We've highlighted several times that the USDA or that the Farm Bill specifically removes hemp from the Controlled Substance Act. And what you see in their opinion, the DEA's opinion, which is the only way that the DEA can overstep its authority is if we allow them to. And one of the things that we always talk about, and the DEA has been doing this. Not everybody in the DEA. A lot of DEA members have liked the way that we're pragmatically handling these substances, and that it's being done by people. There are some people that within the DEA, though, that I think probably are still married to the old ways. And what we end up having happen is innocent people have their lives ruined. And that's not right. And the reality of the matter is they're using our taxpayer money to potentially do these investigations. And it's not, it's there. Technically you can make the argument, or my position is they are there to enforce the laws that were passed by Congress, whether or not, it's not a religion. They should not be putting out opinions like Matt was so kind to, that excerpt that he had on the screen before about, whether or not Delta-9, they're using the term Delta-9 THCa to try to confuse people. They're trying to confuse people because Delta-9 tetrahydrocannabinol is a completely different chemical than THCa is. And by using that term, it could be used to confuse, like Matt said, a judge to who would normally deny a probable cause affidavit, to give them that probable cause affidavit. And then, again, being American, that in my opinion is a huge overstepping of what their authority is meant to be. And Matt's very right. That book is, he talks about it all the time. It is a great example of how it can be systematically done. And unfortunately, it can be done in a way that the public doesn't know it's happening. And again, there are a lot of people who are still suffering from the contents or what was actually written about in that book. So it's really important that everybody understands that if the DEA had authority to do these things, they wouldn't be writing letters. They'd be knocking on your door. Remember that. The DEA and law enforcement don't talk to you before if they have the authority, they're going to come. And that is, they won't play politics. They don't need to play politics. The point is they do not have the authority anymore. And they only have authority if we allow them to. So.
And AJ, I really appreciate you bringing that up and bringing up that critical word authority, because this is what I'm worried about with the hemp industry. So as we know, the DEA's authority is pragmatically limited to the Controlled Substances Act, right? So the problem is that hemp and anything that meets that legal definition of hemp as memorialized by 1639-0 has been removed from the CSA and no longer falls under their purview. So their opinion, left and right, doesn't really matter as it pertains to hemp-derived cannabinoids because they've been removed from the CSA, right? And so that's fine. Tryptamines phenethylamines, lysergamide, aryl cyclohexanamines, all these other fun classes of compounds were not removed from the Controlled Substances Act, right?
They were not.
And tryptamines, for whatever reason, a lot of it has to do with the decriminalization efforts in certain localities and state levels. But the decriminalization efforts have allowed tryptamine products to proliferate. And I'm concerned that some individuals throughout the country. Cool. All right, we're back. Now, and I just want to let everybody know, tryptamines have not been removed from the Controlled Substances Act. And if you're selling tryptamines, there is this thing called the Federal Analog Act. And the federal government has many times done its best to apply Federal Analog Act language to successfully prosecute the manufacturers of tryptamines and tryptamine-containing products throughout the country. And for those of you who are only aware of the Federal Analog Act, please understand that most states have their own version of the same act, and many states, beginning around 2010, 2011, 2012, changed the language of their state laws, actually enhanced the language so that the term substantially similar is defined. Because, as we will talk about the Federal Analog Act here, for those of you who don't know what the Federal Analog Act is, there's a law on the books that states if a compound has a chemical structure that is substantially similar to the chemical structure of a controlled substance that's in Schedule 1 or Schedule 2, and if it has the same pharmacological effect as that Schedule 1 or Schedule 2 controlled substance, that it itself is just automatically considered to be a controlled substance. It itself will be treated as a Schedule 1 or Schedule 2 controlled substance for the purposes of prosecution in the United States of America. This is my area of expertise. I've done this for the last 15 years. So what everybody talks about, and historically, and this is crazy because this law has been on the books for almost 40 years now. Everybody talks about substantially similar, and the fact that they never define the term substantially similar. And similar to like we were talking about with Chevron, we will do our best to mitigate those in the future. But yeah, for what you should know about this law is that it's been successfully used to prosecute individuals all throughout the country. And for 40 years, attorneys have been arguing, but wait, substantially similar is never defined, and there's no language associated with a compliance metric for what is substantially similar or not substantially similar in chemical structure. And so for 40 years, that's what the battle of the experts has discussed in these courtrooms across the country. 15 years ago, my first job as it pertained to chemistry and law was dissecting the Federal Analog Act and trying to figure out what other weaknesses it had. And the first thing that I brought up was, wait a second, they never defined chemical structure. So it begged the question, what is chemical structure? And I learned that for 40 years, all of these courtrooms were discussing molecular geometry. Molecular geometry being one component of chemical structure. Molecular geometry, for the uninitiated, that is the ball and stick models. If you see there on the left side of your screen, the actual geometry of it, like, the ring systems and the little sticks and balls, that's the molecular geometry. So that's what we probably associate traditionally with chemical structure. But for those who don't know about chemistry, it's this magical thing. Most molecules are actually space. Molecules are actually just these amalgamations of energy structured in certain ways. And the electronic structure of a chemical actually does a better job of representing the compound structure, not only what the structure is, but why the structure is valuable. As you know, you are an electromagnetic system. So the electromagnetic potential of molecules goes a long way to interacting with your body there. So what I started doing, and that's my claim to fame, both domestically and abroad, is I'm able to bring up the electronic structures of two chemicals. And these are all, it requires quantum mechanics to calculate these things. But if you go through all the equations, you can get these blobs of color that show whether or not something is substantially similar to another blob of color. So it's an easy way for a jury to recognize whether or not chemical structure is actually substantially similar. So this is what I want to let you know. On this next slide here, I have the structures, both the molecular geometries and the electronic structures of 4-ACO-DMT, which is on your left, and 4-HO-DMT, which is on. So I am the guy, domestically and abroad, that can illuminate a substantial dissimilarity in the electronic structures of these two compounds. And as long as you're not colorblind, you'll see it too. And AJ, you might want to speak to this. Tell me what you think about it. But the center of the molecule, on the left, you'll see it's more of a burnt shade of yellow, as opposed to the right, it's a deep purple. And this is only one snapshot of the molecule. In my software, I'm able to spin it around three-dimensionally. And when you see both chemicals in their true three-dimensional profiles, they're not substantially similar. And that's important, because chemical structure was never defined. So it's good news if you were somebody selling 4-ACO-DMT products and you were worried about being prosecuted federally. You can hire a guy like me, and that hopefully will alleviate some of your concern, but it shouldn't alleviate all your concern, because what you don't know is that chemical structure and its substantial similarity has already been legislated at several state levels throughout the country, including Florida and Tennessee. So if you have questions about the Federal Analog Act, some of these other compounds that have not been removed from the Controlled Substance Act, you can still reach out to me, and I will proceed with extreme caution, because I know what can be done and what can't be done, and what can be marketed as what and what cannot be marketed as what. So if you ever want to reach out to me and learn more, feel free. But I want you to be aware that the situation involving tryptamines is much more complicated than you think. It also extends to other classes of compounds such as lysergamides, aryl cyclohexanamines, phenethylamines. We're in our infancy in understanding all of this, and I don't want somebody marketing Farm Bill compliant tryptamines to experience a rude awakening that not only hurts themselves and their loved ones, but potentially the industry in its more broad form.
Yeah, and Matt, thank you for highlighting that. So, again, just driving home the point that, these arguments, a lot of times the way that these arguments are used is on the layperson when they're in a position of authority. The reality of the matter is, any chemist worth their salt, or anybody who's gone through basic chemistry, biology, understands that although we visualize these molecules by using the ball and stick model and all of that, please remember that you've never interacted with a nucleus ever in your life. All you've ever interacted with is electrons and their fields that they create. And so that color blob is the reality of how medicines work or they don't work, or nutrients work or they don't work. And in fact, when we make chemicals, there's something that we've talked about before called chirality. And you can have molecules that are identical, mirror images of each other, meaning they're non-superimposable, they're mirror images, and one molecule can be biologically active while the other one isn't. And that's 100% because of the electron clouds. Now they will look identical from the color standpoint, but because they're mirror images, they don't fit in the right way with that electronic structure to your receptors. And that is super important. So there are two major factors in where we would maybe start trying to define substantially similar chemically, right? It would be the geometries, or the geometries of the functional groups, meaning the group that's actually going to be interacting with the site or binding to a receptor, and the actual and then the colors that Matt has illuminated for you, the electronegativities of the individual molecules, basically the electron densities. Where are the electrons more likely to be situated? Because that is what's going to interact with the receptors. So by seeing something, you don't need to be a chemist to see, like Matt said, there's green in the center of one of them, which means a very high electronegativity, meaning a lot of electrons are centered around there, the density centered around there. Whereas the red is withdrawing, basically meaning there's what you end up having is a discrepancy on where the electrons are. Whereas on the red one, they're more evenly distributed throughout the molecule with very little variance in where the electron density is most likely. So I kind of fumbled with that. But the reality of the matter is these colors and these structures are the quintessential, most basic ways of understanding how pharmacology works. And it doesn't take a genius to realize that these two things are not similar. I mean, they have red on them, but one has green and the other one doesn't. And so that is very important, especially when it comes to defending yourself and knowing your rights and knowing what you can and can't do as a business owner. And what if you want to take risks, at least take them willingly, knowing the information, the correct information, so that you can arm yourself and protect yourself as you go forward. So, Matt, thank you so much for putting this together.
Man, that's it.
You did a great job. Again, anybody, this is our first try at a live stream. We're going to be doing a little bit more of these, hopefully. And we'll get some questions in, talking about some more of these things. But again, Matt, I really appreciate your time and your expertise. It's always a pleasure working with you. I'm AJ Fabrizio, and that's Matt Gunther. And this was Highly Educated Media Podcast, our first live stream.
Likewise. Thanks, guys.